Chapter 19, Investigations and Ethics. The CISSP exam topics covered in this chapter include Domain 1.0, Security and Risk Management. 1.1, Understand, Adhere to, and Promote Professional Ethics. 1.1.1, ISC Squared Code of Professional Ethics. 1.1.2, Organizational Code of Ethics. 1.6, Understand requirements for investigation types, that is administrative, criminal, civil, regulatory, industry standards. Domain 7.0, Security Operations. 7.1, Understand and comply with investigations. 7.1.1, Evidence collection and handling. 7.1.2, Reporting and documenting. 7.1.3, Investigative techniques. 7.1.4, Digital forensics tools, tactics, and procedures. 7.1.5, Artifacts. For example, computer, network, mobile device. In this chapter, we explore the process of investigating computer security incidents and collecting evidence when appropriate. This chapter also includes a complete discussion of ethical issues and the Code of Conduct for Information Security Practitioners. As a security professional, you must be familiar with the various types of investigations. These include administrative, criminal, civil and regulatory investigations, as well as investigations that involve industry standards. You must be familiar with the standards of evidence used in each investigation type and the forensic procedures used to gather evidence in support of investigations. Investigations. Every information security professional will, at one time or another, encounter a security incident that requires an investigation. In many cases, this investigation will be a brief, informal determination that the matter is not serious enough to warrant further action or the involvement of law enforcement authorities. However, in some cases, the threat posed or damage done will be severe enough to require a more formal inquiry. When this occurs, investigators must be careful to ensure that proper procedures are followed. Failure to abide by the correct procedures may violate the civil rights of those individuals being investigated and could result in a failed prosecution or even legal action against the investigator. Investigation types. Security practitioners may find themselves conducting investigations for a wide variety of reasons. Some of these investigations involve law enforcement and must follow rigorous standards designed to produce evidence that will be admissible in court. Other investigations support internal business processes and require much less rigor. Administrative investigations. Administrative investigations are internal investigations that examine either operational issues or a violation of the organization's policies. They may be conducted as part of a technical troubleshooting effort or in support of other administrative processes, such as human resources disciplinary procedures. Operational investigations examine issues related to the organization's computing infrastructure and have the primary goal of resolving operational issues. For example, an IT team noticing performance issues on their web servers may conduct an operational investigation designed to determine the cause of the performance problems. Tip: administrative investigations may quickly transition to another type of investigation. For example, an investigation into a performance issue may uncover evidence of a system intrusion that may then become a criminal investigation. Operational investigations have the loosest standards for collection of information. They are not intended to produce evidence because they are for internal operational purposes only. Therefore, administrators conducting an operational investigation will only conduct analysis necessary to reach their operational conclusions. The collection need not be thorough or well documented because resolving the issue is the primary goal. In addition to resolving the operational issue, operational investigations often conduct a root cause analysis that seeks to identify the reason that an operational issue occurred. The root cause analysis often highlights issues that require remediation to prevent similar incidents in the future. Administrative investigations that are not operational in nature may require a stronger standard of evidence, especially if they may result in sanctions against an individual. There is no set guideline for the appropriate standard of evidence in these investigations. Security professionals should consult with the sponsor of the investigation as well as their legal team to determine appropriate evidence collection, handling, and retention guidelines for administrative investigations. Criminal investigations. Criminal investigations, typically conducted by law enforcement personnel, investigate the alleged violation of criminal law. Criminal investigations may result in charging suspects with a crime and the prosecution of those charges in criminal court. Most criminal cases must meet the beyond a reasonable doubt standard of evidence. Following this standard, the prosecution must demonstrate that the defendant committed the crime by presenting facts from which there are no other logical conclusions. For this reason, criminal investigations must follow strict evidence collection and preservation processes. Civil investigations. Civil investigations typically do not involve law enforcement, but rather involve internal employees and outside consultants working on behalf of a legal team. They prepare the evidence necessary to present a case in civil court resolving a dispute between two parties. Most civil cases do not follow the beyond a reasonable doubt standard of proof. Instead, they use the weaker preponderance of the evidence standard. Meeting this standard simply requires that the evidence demonstrate that the outcome of this case is more likely than not. For this reason, evidence collection standards for civil investigations are not as rigorous as those used in criminal investigations. Regulatory investigations. Government agencies may conduct regulatory investigations when they believe that an individual or corporation has violated administrative law. Regulators typically conduct these investigations with a standard of proof commensurate with the venue where they expect to try their case. Regulatory investigations vary widely in scope and procedure and are often conducted by government agents. Industry standards. Some regulatory investigations may not involve government agencies. These are based on industry standards, such as the Payment Card Industry Data Security Standard, PCI DSS. These industry standards are not laws, but are contractual obligations entered into by the participating organizations. In some cases, including PCI DSS, the organization may be required to submit to audits, assessments, and investigations conducted by an independent third party. Failure to participate in these investigations or negative investigation results may lead to fines or other sanctions. Therefore, investigations into violations of industry standards should be treated in a similar manner as regulatory investigations. Electronic discovery. In legal proceedings, each side has a duty to preserve evidence related to the case, and, through the discovery process, share information with their adversary in the proceedings. This discovery process applies to both paper records and electronic records, and the electronic discovery, or e-discovery process, facilitates the process of electronic information for disclosure. The Electronic Discovery Reference Model, EDRM, describes a standard process for conducting e-discovery with 9 aspects. Information governance ensures that information is well organized for future e-discovery efforts. Identification locates the information that may be responsive to a discovery request when the organization believes that litigation is likely. Preservation ensures that potentially discoverable information is protected against alteration or deletion. collection, gathers the relevant information centrally for use in the e-discovery process. Processing screens the collected information to perform a rough cut of irrelevant information, reducing the amount of information requiring detailed screening. Review examines the remaining information to determine what information is relevant to the request and removing any information protected by attorney-client privilege. Analysis performs deeper inspection of the content and context of remaining information. Production places the information into a format that may be shared with others and delivers it to other parties, such as opposing counsel. Presentation displays the information to witnesses, the court, and other parties. Tip: for more information on the EDRM, see edrm.net/resources/frameworks-and-standards/EDRM-model. Conducting e-discovery is a complex process and requires careful coordination between IT professionals and legal counsel. Evidence. To successfully prosecute a crime, the prosecuting attorneys must provide sufficient evidence to prove an individual's guilt beyond a reasonable doubt. In the following sections, we'll explain the requirements that evidence must meet before it is allowed in court, the various types of evidence that may be introduced, and the requirements for handling and documenting evidence. The items of evidence that you maintain and may use in court are also known as artifacts and may include physical devices, such as computers, mobile devices, and network devices, the logs and data generated by those devices, and many other forms of evidence. Tip: the National Institute of Standards and Technology's Guide to Integrating Forensic Techniques into Incident Response, SP 886, is a great reference and is available at nist.gov/integrating-forensic-techniques-incident-response. Admissible evidence. There are three basic requirements for evidence to be introduced into a court of law. To be considered admissible evidence, it must meet all three of these requirements, as determined by a judge, prior to being discussed in open court. The evidence must be relevant to determining a fact. The fact that the evidence seeks to determine must be material, that is, related to the case. The evidence must be competent, meaning it must have been obtained legally. Evidence that results from an illegal search would be inadmissible because it is not competent. Types of evidence. Many different types of evidence can be used in a court of law. Depending on the reference you consult, these may be grouped in many different ways. However, you should be familiar with these four major categories: real evidence, documentary evidence, testimonial evidence, and demonstrative evidence. Each has slightly different additional requirements for admissibility. Real evidence. Real evidence, also known as object evidence, consists of things that may actually be brought into a court of law. In common criminal proceedings, this may include items such as a murder weapon, clothing, or other physical objects. In a computer crime case, real evidence might include seized computer equipment, such as a keyboard with fingerprints on it or a hard drive from a malicious hacker's computer system. Depending on the circumstances, real evidence may also be conclusive evidence, such as deoxyribonucleic acid, DNA, that is incontrovertible. Documentary evidence. Documentary evidence includes any written items brought into court to prove a fact at hand. This type of evidence must also be authenticated. For example, if an attorney wants to introduce a computer log as evidence, they must bring a witness, for example the system administrator, into court to testify that the log was collected as a routine business practice and is indeed the actual log that the system collected. Two additional evidence rules apply specifically to documentary evidence. The best evidence rule states that when a document is used as evidence in a court proceeding, the original document must be introduced. Copies or descriptions of original evidence, known as secondary evidence, will not be accepted as evidence unless certain exceptions to the rule apply. The parallel evidence rule states that when an agreement between parties is put into written form, the written document is assumed to contain all the terms of the agreement, and no verbal agreements may modify the written agreement. If documentary evidence meets the materiality, competency, and relevancy requirements, and also complies with the best evidence and parallel evidence rules, it can be admitted into court. Chain of evidence. Real evidence, like any type of evidence, must meet the relevancy, materiality, and competency requirements before being admitted into court. Additionally, real evidence must be authenticated. This can be done by a witness who can actually identify an object as unique. For example, that knife with my name on the handle is the one that the intruder took off the table in my house and used to stab me, and unaltered, meaning that it has not been tampered with from the time of collection until the time of use in court. In many cases, it is not possible for a witness to uniquely identify an object in court. In those cases, a chain of evidence, also known as a chain of custody, must be established. The chain of evidence documents everyone who handles evidence, including the police who originally collect it, the evidence technicians who process it, and the lawyers who use it in court. The location of the evidence must be fully documented from the moment it was collected to the moment it appears in court to ensure that it is indeed the same item. This requires thorough labeling of evidence and comprehensive logs, noting who had access to the evidence at specific times and the reasons they required such access. When evidence is labeled to preserve the chain of custody, the label should include the following types of information about the collection: general description of the evidence, time and date the evidence was collected, exact location the evidence was collected from, name of the person collecting the evidence, relevant circumstances surrounding the collection. Each person who handles the evidence must sign the chain of custody log, indicating the time they took direct responsibility for the evidence and the time they handed it off to the next person in the chain of custody. The chain must provide an unbroken sequence of events accounting for the evidence from the time it was collected until the time of the trial. Testimonial evidence. Testimonial evidence is, quite simply, evidence consisting of the testimony of a witness, either verbal testimony in court or written testimony in a recorded deposition. Witnesses must take an oath agreeing to tell the truth, and they must have personal knowledge on which their testimony is based. Furthermore, witnesses must remember the basis for their testimony. They may consult written notes or records to aid their memory. Witnesses can offer direct evidence, oral testimony that proves or disproves a claim based on their own direct observation. The testimonial evidence of most witnesses must be strictly limited to direct evidence based on the witness's factual observations. However, this does not apply if a witness has been accepted by the court as an expert in a certain field. In that case, the witness may offer an expert opinion based on the other facts presented and their personal knowledge of the field. Hearsay rule. When a witness offers testimony in court, they must normally avoid the act of hearsay, meaning that they cannot testify about what someone else told them outside of court, because the court has no way to substantiate that evidence and find it admissible. That said, the hearsay rule is one that has many, many exceptions. These include past testimony given by a witness under oath that is no longer available, a statement made against the interest of the person making the statement, a dying utterance, public records, and many other situations. An extremely important exception to this rule for forensic analysts is the business records exception to the hearsay rule. This says that business records, such as the logs generated by a computer system, may be admitted as evidence if they were made at the time of the event by someone or something with direct knowledge, that they were kept in the course of regular business activity, and that keeping those records is a regular practice of the organization. Records admitted under the business records exception must be accompanied by the testimony of an individual qualified to show that these criteria were met. This exception is commonly used to introduce system logs and other records generated by computer systems. Demonstrative evidence. Demonstrative evidence is evidence used to support testimonial evidence. It consists of items that may or may not be admitted into evidence themselves, but are used to help a witness explain a concept or clarify an issue. For example, demonstrative evidence might include a diagram explaining the contents of a network packet or showing the process used to conduct a distributed denial of service attack. The admissibility of demonstrative evidence is a matter left to the trial court, with the general principle that demonstrative evidence must assist the jury in understanding a case. Artifacts, evidence collection, and forensic procedures. Collecting digital evidence is a tricky process and should be attempted only by professional forensic technicians. The International Organization on Computer Evidence, IOCE, outlines 6 principles to guide digital evidence technicians as they perform media analysis, network analysis, and software analysis in the pursuit of forensically recovered evidence. When dealing with digital evidence, all of the general forensic and procedural principles must be applied. Upon seizing digital evidence, actions taken should not change that evidence. When it is necessary for a person to access original digital evidence, that person should be trained for this purpose. All activity relating to the seizure, access, storage, or transfer of digital evidence must be fully documented, preserved, and available for review. An individual is responsible for all actions taken with respect to digital evidence while the digital evidence is in their possession. Any agency that is responsible for seizing, accessing, storing, or transferring digital evidence is responsible for compliance with these principles. As you conduct forensic evidence collection, it is important to preserve the original evidence. Remember that the very conduct of your investigation may alter the evidence you are evaluating. Therefore, when analyzing digital evidence, it's best to work with a copy of the actual evidence whenever possible. For example, when conducting an investigation into the contents of a hard drive, make an image of that drive, seal the original drive in an evidence bag, and then use the disk image for your investigation. Media analysis. Media analysis, a branch of computer forensic analysis, involves the identification and extraction of information from storage media. This may include magnetic media, for example, hard disks, tapes, or optical media, for example, CDs, DVDs, Blu-ray discs. Techniques used for media analysis may include the recovery of deleted files from unallocated sectors of the physical disk, the live analysis of storage media connected to a computer system, especially useful when examining encrypted media, and the static analysis of forensic images of storage media. When gathering information from storage devices, analysts should never access hard drives or other media from a live system. Instead, they should power off the system after collecting other evidence, remove the storage device, and then attach the storage device to a dedicated forensic workstation using a write blocker. Write blockers are hardware adapters that physically sever the portion of the cable used to connect the storage device that would write data to the device, reducing the likelihood of accidental tampering with the device. After connecting the device to a live workstation, the analyst should immediately calculate a cryptographic hash of the device contents and then use forensic tools to create a forensic image of the device, a bitwise copy of the data stored on the device. The analyst should then compute the cryptographic hash of that image to ensure that it is identical to the original media contents. After creating and verifying a forensic image, the original image file should be preserved as evidence. Analysts should create copies of that image, verifying the integrity of the hash, and then use those images for any analysis. This careful process reduces the likelihood of error and ensures the preservation of the chain of custody. In-memory analysis. Investigators often wish to collect information from the memory of live systems. This is a tricky undertaking since it can be difficult to work with memory without actually altering its contents. When gathering the contents of memory, analysts should use trusted tools to generate a memory dump file and place it on a forensically prepared device, such as a USB drive. The memory dump file contains all the contents collected from memory and may then be used for analysis. As with other types of digital evidence, the analyst collecting the memory dump should compute a cryptographic hash of the dump file to later prove its authenticity. The analyst should preserve the original collected dump and work from copies of that dump file. Network analysis. Forensic investigators are also often interested in the activity that took place over the network during a security incident. This is often difficult to reconstruct due to the volatility of network data. If it isn't deliberately recorded at the time it occurs, it generally is not preserved. Network forensic analysis, therefore, often depends on either prior knowledge that an incident is underway or the use of pre-existing security controls that log network activity. These include intrusion detection and prevention system logs, network flow data captured by a flow monitoring system, packet captures deliberately collected during an incident, logs from firewalls and other network security devices. When collecting data directly from a network during a live analysis, forensic technicians should use a span port on a switch, which mirrors data sent to one or more other ports for analysis, or a network tap, which is a hardware device that performs the same functions as a span port. Both of these approaches generate packet dumps without actually altering the network traffic being exchanged between two systems. In cases where this is not possible, the analyst may run a software protocol analyzer on one of the communicating systems, but this approach is not as reliable as using a dedicated hardware device. After collecting network packets, they should be treated in the same manner as any other digital evidence. The tools creating the packet capture should write them to forensically prepared media. Analysts should compute cryptographic hashes of the original evidence files and work only with copies of those original files. The task of the network forensic analyst is to collect and correlate information from these disparate sources and produce as comprehensive a picture of network activity as possible. Software analysis. Forensic analysts may also be called on to conduct forensic reviews of applications or the activity that takes place within a running application. In some cases, when malicious insiders are suspected, the forensic analyst may be asked to conduct a review of software code, looking for backdoors, logic bombs, or other security vulnerabilities. For more on these topics, see Chapter 21, Malicious Code and Application Attacks. In other cases, forensic analysts may be asked to review and interpret the log files from application or database servers, seeking other signs of malicious activity, such as SQL injection attacks, privilege escalations, or other application attacks. These are also discussed in Chapter 21. Software analysis may also include the validation of file hash values against known file types. The National Software Reference Library, NSRL, maintained by the National Institute of Standards and Technology, includes the cryptographic hash values for over 130 million known applications, making it easier for forensic analysts to detect authentic and manipulated files. For more information on the NSRL, see nist.gov/itl/ssd/software-quality-group/ National-Software-Reference-Library-NSRL. Hardware/embedded device analysis. Finally, forensic analysts often must review the contents of hardware and embedded devices. This may include a review of personal computers, smartphones, tablet computers, embedded computers in cars, security systems, and other devices. Analysts conducting these reviews must have specialized knowledge of the systems under review. An organization may have to call in expert consultants who are familiar with the memory, storage systems, and operating systems of such devices. Because of the complex interactions between software, hardware, and storage, the discipline of hardware analysis requires skills in both media analysis and software analysis. Tip: the Scientific Working Group on Digital Evidence, swgde.org/home, is a consortium of forensic analysts led by the U.S. Federal Bureau of Investigation, FBI. They produce detailed guidance on gathering digital evidence from many different sources and are invaluable references for digital forensic analysts. Investigation process. When you initiate a computer security investigation, you should first assemble a team of competent analysts to assist with the investigation. This team should operate under the organization's existing incident response policy and be given a charter that clearly outlines the scope of the investigation, the authority, roles, and responsibilities of the investigators, and any rules of engagement that they must follow while conducting the investigation. These rules of engagement define and guide the actions that investigators are authorized to take at different phases of the investigation, such as calling in law enforcement, interrogating suspects, collecting evidence, and disrupting system access. Gathering evidence. It is common to confiscate equipment, software, or data to perform a proper investigation. The manner in which the evidence is confiscated is important. The confiscation of evidence must be carried out in a proper fashion. There are several possible approaches. First, the person who owns the evidence could voluntarily surrender it or grant consent to a search. This method is generally appropriate only when the attacker is not the owner. Few guilty parties willingly surrender evidence they know will incriminate them. Less experienced attackers may believe they have successfully covered their tracks and voluntarily surrender important evidence. A good forensic investigator can extract much covered-up information from a computer. In most cases, asking for evidence from a suspected attacker just alerts the suspect that you are close to taking legal action. Tip: in the case of an internal investigation, you will gather the vast majority of your information through voluntary surrender. Most likely, you're conducting the investigation under the auspices of a senior member of management, who will authorize you to access any organizational resources necessary to complete your investigation. Second, you could get a court to issue a subpoena or court order that compels an individual or organization to surrender evidence, and then have the subpoena served by law enforcement. Again, this course of action provides sufficient notice for someone to alter the evidence and render it useless in court. Third, a law enforcement officer performing a legally permissible duty may seize evidence that is visible to the officer in plain view and where the officer has probable cause to believe that it is associated with criminal activity. This is known as the plain view doctrine. The fourth option is a search warrant. This option should be used only when you must have access to evidence without tipping off the evidence's owner or other personnel. You must have a strong suspicion with credible reasoning to convince a judge to pursue this course of action. Finally, a law enforcement officer may collect evidence when exigent circumstances exist. This means that a reasonable person would believe that the evidence would be destroyed if not immediately collected, or that another emergency exists, such as the risk of physical harm. When officers enter a premises under exigent circumstances, they may conduct a warrantless search. These options apply to confiscating equipment, both inside and outside an organization. But there is another step you can take to ensure that the confiscation of equipment that belongs to your organization is carried out properly. It is common to have all new employees sign an agreement that provides consent to search and seize any necessary evidence during an investigation. In this manner, consent is provided as a term of the employment agreement. This makes confiscation much easier and reduces the chances of a loss of evidence while waiting for legal permission to seize it. Make sure your security policy addresses this important topic. When conducting searches in the workplace, an important consideration is whether the employee has a reasonable expectation of privacy. Outside of government workplaces, most jurisdictions have laws or precedents that state that employees do not have an expectation of privacy under most workplace situations. Employers generally have the authority to search electronic systems that they own and operate. The law gets much more nuanced and complex when searches might violate personal privacy, such as searching an employee's person or belongings. In cases where this may be necessary, always consult an attorney to ensure that the search is done in compliance with all local laws and regulations. Calling in law enforcement. One of the first decisions that must be made in an investigation is whether law enforcement authorities should be called in. This is a relatively complicated decision that should involve senior management officials. There are many factors in favor of calling in the experts. For example, the FBI runs a nationwide cyber division that serves as a center of excellence for the investigation of cybercrimes. Additionally, local FBI field offices now have agents who are specifically trained to handle cybercrime investigations. These agents investigate federal offenses in their region and may also consult with local law enforcement upon request. The U.S. Secret Service has similarly skilled staff in their headquarters and field offices. On the other hand, two major factors may cause a company to shy away from calling in the authorities. First, the investigation will more than likely become public and may embarrass the company. Second, law enforcement authorities are bound to conduct an investigation that complies with the Fourth Amendment and other legal requirements that may not apply if the organization conducted its own private investigation. Search warrants. Even the most casual viewer of American crime television is familiar with the question, do you have a warrant? The Fourth Amendment of the U.S. Constitution outlines the burden placed on investigators to have a valid search warrant before conducting certain searches, and the legal hurdles they must overcome to obtain a warrant. Extract. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This amendment contains several important provisions that guide the activities of law enforcement personnel. Investigators must obtain a warrant before searching a person's private belongings, assuming that there is a reasonable expectation of privacy. There are a number of documented exceptions to this requirement, such as when an individual consents to a search, the evidence of a crime is in plain view, or there is a life-threatening emergency necessitating the search. Warrants can be issued only based on probable cause. There must be some type of evidence that a crime took place and that the search in question will yield evidence relating to that crime. The standard of probable cause required to get a warrant is much weaker than the standard of evidence required to secure a conviction. Most warrants are sworn out based solely on the testimony of investigators. Warrants must be specific in their scope. The warrant must contain a detailed description of the legal bounds of the search and seizure. If investigators fail to comply with even the smallest detail of these provisions, they may find their warrant invalidated and the results of the search deemed inadmissible. This leads to another one of those American colloquialisms: they got off on a technicality. Conducting the investigation. If you elect not to call in law enforcement, you should still attempt to abide by the principles of a sound investigation to ensure the accuracy and fairness of your inquiry. It is important to remember a few key principles. Never conduct your investigation on an actual system that was compromised. Take the system offline, make a backup, and use the backup to investigate the incident. Never attempt to hack back and avenge a crime. You may inadvertently attack an innocent third party and find yourself liable for computer crime charges. If in doubt, call in expert assistance. If you don't want to call in law enforcement, contact a private investigations firm with specific experience in the field of computer security investigations. Interviewing individuals. During the course of an investigation, you may find it necessary to speak with individuals who might have information relevant to your investigation. If you seek only to gather information to assist with your investigation, this is called an interview. If you suspect the person of involvement in a crime and intend to use the information gathered in court, this is called an interrogation. Before conducting an interview or interrogation, the interviewer should carefully plan the topics to be discussed with the subject. It is helpful to begin with a standard checklist of topics/questions and then customize that list based on the unique circumstances of the interview. This helps ensure that all topics are addressed and that interviews of different subjects are conducted consistently. Of course, the interviewer must use their own skill and discretion to conduct the interview in an appropriate manner, which may involve deviating from the checklist based on the behavior of the subject, information uncovered during the interview, and other circumstances. Interviewing and interrogating individuals are specialized skills and should be performed only by trained investigators. Improper techniques may jeopardize the ability of law enforcement to successfully prosecute an offender. Additionally, many laws govern holding or detaining individuals, and you must abide by them if you plan to conduct private interrogations. Always consult an attorney before conducting any interviews. Data integrity and retention. No matter how persuasive evidence may be, it can be thrown out of court if you somehow alter it during the evidence collection process. Make sure you can prove that you maintained the integrity of all evidence. But what about the integrity of data before it is collected? You may not detect all incidents as they are happening. Sometimes, an investigation reveals that there were previous incidents that went undetected. It is discouraging to follow a trail of evidence and find that a key log file that could point back to an attacker has been purged. Carefully consider the fate of log files or other possible evidence locations. A simple archiving policy can help ensure that key evidence is available upon demand, no matter how long ago the incident occurred. Because many log files can contain valuable evidence, attackers often attempt to sanitize them after a successful attack. Take steps to protect the integrity of log files and to deter their modification. One technique is to implement remote logging, where all systems on the network send their log records to a centralized log server that is locked down against attack and does not allow for the modification of data. This technique provides protection from post-incident log file cleansing. Administrators also often use digital signatures to prove that log files were not tampered with after initial capture. For more information on digital signatures, see Chapter 7, PKI and Cryptographic Applications. As with every aspect of security planning, there is no single solution. Get familiar with your system and take the steps that make the most sense for your organization to protect it. Reporting and documenting investigations. Every investigation you conduct should result in a final report that documents the goals of the investigation, the procedures followed, the evidence collected, and the final results of the investigation. The degree of formality behind this report will vary based on the organization's policy and procedures, as well as the nature of the investigation. Preparing formal documentation is important because it lays the foundation for escalation and potential legal action. You may not know when an investigation begins, or even after it concludes, that it will be the subject of legal action, but you should prepare for that eventuality. Even internal investigations into administrative matters may become part of an employment dispute or other legal action. The use of standard procedures and checklists for the collection and documentation of evidence helps ensure that evidence is collected in a manner that will be admissible down the road. Organizations should also ensure that anyone involved in the collection or analysis of potential evidence receive proper training. It's a good idea to establish a relationship with your corporate legal personnel and the appropriate law enforcement agencies. Find out who the appropriate law enforcement contacts are for your organization and talk with them. When the time comes to report an incident, your efforts at establishing a prior working relationship will pay off. You will spend far less time in introductions and explanations if you already know the person with whom you are talking. It is a good idea to identify in advance a single point of contact in your organization who will act as your liaison with law enforcement. This provides two benefits. First, it ensures that law enforcement hears a single perspective from your organization and knows the go-to person for updates. Second, it allows the pre-designated contact to develop working relationships with law enforcement personnel. Note: one great way to establish technical contacts with law enforcement is to participate in the FBI's InfraGard program. InfraGard exists in most major metropolitan areas in the United States and provides a forum for law enforcement and business security professionals to share information in a closed environment. For more information, visit infragard.org. Major categories of computer crime. There are many ways to attack a computer system and many motivations to do so. Information system security practitioners generally put crimes against or involving computers into different categories. Simply put, a computer crime is a crime or violation of a law or regulation that involves a computer. The crime could be against the computer, or the computer could have been used in the actual commission of the crime. Each of the categories of computer crimes represents the purpose of an attack and its intended result. Any individual who violates one or more of your security policies is considered to be an attacker. An attacker uses different techniques to achieve a specific goal. Understanding the goals helps clarify the different types of attacks. Remember that crime is crime, and the motivations behind computer crime are no different from the motivations behind any other type of crime. The only real difference may be in the methods the attacker uses to strike. Computer crimes are generally classified as one of the following types: military and intelligence attacks, business attacks, financial attacks, terrorist attacks, grudge attacks, thrill attacks, hacktivist attacks. It is important to understand the differences among the categories of computer crime to best understand how to protect a system and react when an attack occurs. The type and amount of evidence left by an attacker is often dependent on their expertise. In the following sections, we'll discuss the different categories of computer crimes and the types of evidence you might find after an attack. This evidence can help you determine the attacker's actions and intended target. You may find that your system was only a link in the chain of network hops used to reach the real victim, making the trail harder to follow back to the true attacker. Military and intelligence attacks. Military and intelligence attacks are launched primarily to obtain secret and restricted information from law enforcement or military and technological research sources. The disclosure of such information could compromise investigations, disrupt military planning, and threaten national security. Attacks to gather military information or other sensitive intelligence often precede other, more damaging attacks. An attacker may be looking for the following kinds of information: military descriptive information of any type, including deployment information, readiness information, and order of battle plans; secret intelligence gathered for military or law enforcement purposes; descriptions and storage locations of evidence obtained in a criminal investigation; any secret information that could be used in a later attack. Because of the sensitive nature of information collected and used by the military and intelligence agencies, their computer systems are often attractive targets for experienced attackers. To protect from more numerous and more sophisticated attackers, you will generally find more formal security policies in place on systems that house such information. As you learned in Chapter 1, Security Governance Through Principles and Policies, data can be classified according to sensitivity and stored on systems that support the required level of security. It is common to find stringent perimeter security as well as internal controls to limit access to classified documents on military and intelligence agency systems. You can be sure that serious attacks to acquire military or intelligence information are carried out by professionals. Professional attackers are generally very thorough in covering their tracks. There is usually little evidence to collect after such an attack. Attackers in this category are the most successful and the most satisfied when no one is aware that an attack occurred. Advanced persistent threats. Recent years have marked the rise of sophisticated attacks known as Advanced Persistent Threats, APTs. The attackers are well-funded and have advanced technical skills and resources. They act on behalf of a nation-state, organized crime, terrorist group or other sponsor, and wage highly effective attacks against a very focused target. Business attacks. Business attacks focus on illegally jeopardizing the confidentiality, integrity, or availability of information and systems operated by a business. For example, an attacker might focus on obtaining an organization's confidential information. This could be information that is critical to the operation of the organization, such as a secret recipe, or information that could damage the organization's reputation if disclosed, such as personal information about its employees. The gathering of a competitor's confidential intellectual property, also called corporate espionage or industrial espionage, is not a new phenomenon. Businesses have used illegal means to acquire competitive information for many years. Perhaps what has changed is the source of the espionage, as state-sponsored espionage has become a significant threat. The temptation to steal a competitor's trade secrets, and the ease with which a savvy attacker can compromise some computer systems make this type of attack attractive. The goal of these attacks may be solely to extract confidential information. The use of the information gathered during the attack usually causes more damage than the attack itself. A business that has suffered an attack of this type can be put into a position from which it might not ever recover. Other attacks may focus on integrity and/or availability of information. For example, although ransomware attacks may jeopardize the confidentiality of information, their primary purpose is to disrupt availability, preventing the target from accessing their own data and forcing the payment of a ransom to restore access. Financial attacks. Financial attacks are carried out to unlawfully obtain money or services. They are the type of computer crime you most commonly hear about in the news. The goal of a financial attack could be to steal credit card numbers, increase the balance in a bank account, or obtain fraudulent funds transfers. Shoplifting and burglary are both examples of financial attacks. You can usually tell the sophistication of the attacker by the dollar amount of the damages. Less sophisticated attackers seek easier targets, but although the damages are usually minimal, they can add up over time. Financial attacks launched by sophisticated attackers can result in substantial damages. Even attacks that siphon off small amounts of money in each transaction can accumulate and become serious financial attacks that result in losses amounting to millions of dollars. As with the attacks previously described, the ease with which you can detect an attack and track an attacker is largely dependent on the attacker's skill level. Financial attacks may also take the form of cybercrime for hire, where the attacker engages in mercenary activity, conducting cyber attacks against targets for their clients. One of the most common examples of this type of attack is in the conduct of distributed denial of service, DDoS attacks. Attackers have assembled large botnets of systems they then lease out to customers for use in DDoS attacks. Here, the attacker actually has no motivation other than receiving money from the customer, who has some other motivation for the attack. Terrorist attacks. Terrorist attacks are a reality in modern society. Our increasing reliance on information systems makes them more and more attractive to terrorists. Such attacks differ from military and intelligence attacks. The purpose of a terrorist attack is to disrupt normal life and instill fear, whereas a military or intelligence attack is designed to extract secret information. Intelligence gathering generally precedes any type of terrorist attack. The very systems that are victims of a terrorist attack were probably compromised in an earlier attack to collect intelligence. The more diligent you are in detecting attacks of any type, the better prepared you will be to intervene before more serious attacks occur. Possible targets of a computer terrorist attack could be systems that regulate power plants or control telecommunications or power distribution. Many such control and regulatory systems are computerized and vulnerable to terrorist action. In fact, the possibility exists of a simultaneous physical and computerized terrorist attack. Our ability to respond to such an attack would be greatly diminished if the physical attack were simultaneously launched with a computer attack designed to knock out power and communications. Most large power and communications companies have dedicated a security staff to ensure the security of their systems. But many smaller businesses that have systems connected to the Internet are more vulnerable to attacks. You must diligently monitor your systems to identify any attacks, and then respond swiftly when an attack is discovered. Grudge attacks. Grudge attacks are attacks that are carried out to damage an organization or a person. The damage could be in the loss of information or information processing capabilities, or harm to the organization or a person's reputation. The motivation behind a grudge attack is usually a feeling of resentment, and the attacker could be a current or former employee or someone who wishes ill will upon an organization. The attacker is disgruntled with the victim and takes out their frustration in the form of a grudge attack. An employee who has recently been fired is a prime example of a person who might carry out a grudge attack to get back at the organization. Another example is a person who has been rejected in a personal relationship with another employee. The person who has been rejected might launch an attack to destroy data on the victim's system. Real-world scenario. The insider threat. It's common for security professionals to focus on the threat from outside an organization. Indeed, many of our security technologies are designed to keep unauthorized individuals out. We often don't pay enough or much attention to protecting our organizations against the malicious insider, even though they often pose the greatest risk to our computing assets. One of the authors of this book recently wrapped up a consulting engagement with a medium-sized subsidiary of a large, well-known corporation. The company had suffered a serious security breach involving the theft of thousands of dollars and the deliberate destruction of sensitive corporate information. The IT leaders in the organization needed someone to work with them to diagnose the cause of the event and protect themselves against similar events in the future. After only a very small amount of digging, it became apparent that they were dealing with an insider attack. The intruder's actions demonstrated knowledge of the company's IT infrastructure, as well as an understanding of which data was most important to the company's ongoing operations. Additional investigation revealed that the culprit was a former employee who ended his employment with the firm on less than favorable terms. He left the building with a chip on his shoulder and an axe to grind. Unfortunately, he was a system administrator with a wide range of access to corporate systems, and the company had an immature deprovisioning process that failed to remove all of his access upon his termination. He simply found several accounts that remained active and used them to access the corporate network through a VPN. The moral of this story? Don't underestimate the insider threat. Take the time to evaluate your controls to mitigate the risk that malicious current and former employees pose to your organization. It's also important to understand that not all insider attacks are malicious in origin. Employees with privileged access to systems may make errors that jeopardize security and unintentionally enable an external attacker to carry out a malicious attack. Your security policy should address the potential of insider attacks. For example, as soon as an employee is terminated, all system access for that employee should be terminated. This action reduces the likelihood of a grudge attack and removes unused access accounts that could be used in future attacks. Although most grudge attackers are just disgruntled people with limited hacking and cracking abilities, some possess the skills to cause substantial damage. An unhappy cracker can be a handful for security professionals. Take extreme care when a person with known cracking ability leaves your company. At the least, you should perform a vulnerability assessment of all systems the person could access. You may be surprised to find one or more backdoors left in the system. For more on backdoors, see Chapter 21. But even in the absence of any backdoors, a former employee who is familiar with the technical architecture of the organization may know how to exploit its weaknesses. Grudge attacks can be devastating if allowed to occur unchecked. Diligent monitoring and assessing systems for vulnerabilities is the best protection from most grudge attacks. Thrill attacks. Thrill attacks are the attacks launched only for the fun of it. Attackers who lack the ability to devise their own attacks will often download programs that do their work for them. These attackers are often called script kiddies because they run only other people's programs or scripts to launch an attack. The main motivation behind these attacks is the high of successfully breaking into a system. If you are the victim of a thrill attack, the most common fate you will suffer is a service interruption. Although an attacker of this type may destroy data, the main motivation is to compromise a system and perhaps use it to launch an attack against another victim. One common type of thrill attack involves website defacements, where the attacker compromises a web server and replaces an organization's legitimate web content with other pages, often boasting about the attacker's skills. For example, attackers launched a series of automated website defacement attacks in 2017 that exploited a vulnerability in the widely used WordPress web publishing platform. Those attacks managed to deface more than 1.8 million web pages in 1 week. Hacktivists. Recently, the world has seen a rise in the field of hacktivism. These attackers, known as hacktivists, The combination of hacker and activist often combined political motivations with the thrill of hacking. They organize themselves loosely into groups with names like Anonymous and LulzSec and use tools like the Low Orbit Ion Cannon, LOIC, to create large-scale DOS attacks with little knowledge required. Their purpose is to disrupt the activity of organizations that they differ with philosophically. At the extreme end of hacktivism, suicide hackers engage in highly destructive activity with the knowledge that they will most likely be caught. Their motivations may differ, but they feel that they have nothing to lose and do not attempt to hide their activity. Ethics. Security professionals hold themselves and each other to a high standard of conduct because of the sensitive positions of trust they occupy. The rules that govern personal conduct are collectively known as rules of ethics. They are the moral codes and rules of personal behavior that guide our day-to-day activities in any realm. In the world of business, ethics describe how a business should govern itself to ensure that its actions are appropriate and just. Business ethics cover a wide variety of topics, including financial dealings, conflicts of interest, non-discrimination, and social responsibility. In the world of cybersecurity, ethical codes guide the conduct of cybersecurity professionals to ensure that they act in a manner that is responsible and just. Several organizations have recognized the need for standard ethics rules or codes and have devised guidelines for ethical behavior. We present several codes of ethics in the following sections. These rules are not laws. They are minimum standards for professional behavior. They should provide you with a basis for sound ethical judgment. We expect all security professionals to abide by these guidelines, regardless of their area of specialty or employer. Make sure you understand and agree with the codes of ethics outlined in the following sections. Organizational Code of Ethics. Almost every organization has its own code of ethics that is published to employees to help guide their everyday work. These may come in the form of an official ethics statement, or they may be embodied in the policies and procedures that the organization uses to carry out routine business activities. In cases where an ethical code is published as a separate statement, it is usually high-level, designed to provide general guidance and direction rather than address specific situations. The organizational code of ethics may be supplemented by other policies and rules that provide detailed guidance on specific issues. For example, the U.S. government has a code of ethics for government service that is written into federal law. Passed by Congress in 1980, this code says that any person in government service should put loyalty to the highest moral principles and to country above loyalty to persons, party, or government department. Uphold the Constitution, laws and regulations of the United States and of all governments therein, and never be a party to their evasion. Give a full day's labor for a full day's pay, giving earnest effort and best thought to the performance of duties. Seek to find and employ more efficient and economical ways of getting tasks accomplished. Never discriminate unfairly by the dispensing of special favors or privileges to anyone, whether for remuneration or not, and never accept, for himself or herself or for family members, favors or benefits under circumstances which might be construed by reasonable persons as influencing the performance of governmental duties. Make no private promises of any kind binding upon the duties of office, since a government employee has no private word which can be binding on public duty. Engage in no business with the government, either directly or indirectly, which is inconsistent with the conscientious performance of governmental duties. Never use any information gained confidentially in the performance of governmental duties as a means of making private profit. Expose corruption wherever discovered. Uphold these principles, ever conscious that public office is a public trust. ISC² Code of Ethics. The governing body that administers the CISSP certification is the International Information Systems Security Certification Consortium, or ISC squared. The ISC squared Code of Ethics was developed to provide the basis for CISSP behavior. It is a simple code with a preamble and 4 canons. The following is a short summary of the major concepts of the Code of Ethics. Tip: all CISSP candidates should be familiar with the entire ISC squared Code of Ethics because they have to sign an agreement that they will adhere to this code. We won't cover the code in depth, but you can find further details about the ISC squared's Code of Ethics at isc2.org/ethics. You need to visit this site and read the entire code. Code of Ethics Preamble. The Code of Ethics Preamble is as follows: the safety and welfare of society and the common good, duty to our principles and to each other, requires that we adhere and be seen to adhere to the highest ethical standards of behavior. Therefore, strict adherence to this code is a condition of certification. Code of Ethics Canons. The Code of Ethics, isc2.org/ethics #, includes the following canons. 1. Protect society, the common good, necessary public trust and confidence, and the infrastructure. Security professionals have great social responsibility. We are charged with the burden of ensuring that our actions benefit the common good. 2. Act honorably, honestly, justly, responsibly, and legally. Integrity is essential to the conduct of our duties. We cannot carry out our duties effectively if others within our organization, the security community, or the general public have doubts about the accuracy of the guidance we provide or the motives behind our actions. 3. Provide diligent and competent service to principals. Although we have responsibilities to society as a whole, we also have specific responsibilities to those who have hired us to protect their infrastructure. We must ensure that we are in a position to provide unbiased, competent service to our organization. 4. Advance and protect the profession. Our chosen profession changes on a continuous basis. As security professionals, we must ensure that our knowledge remains current and that we contribute our own knowledge to the community's common body of knowledge. Code of Ethics Complaints. ISC squared members who encounter a potential violation of the Code of Ethics may report the possible violation to ISC squared for investigation by filing a formal ethics complaint. This complaint must identify the specific canon of the Code of Ethics that the member believes has been violated. Furthermore, complaints are only accepted from those who believe they have been injured by the alleged behavior. This personal injury provides standing to file a complaint and is determined based on the canon involved. Any member of the general public may file a complaint involving Canons 1 or 2. Only an employer or someone with a contracting relationship with the individual may file a complaint under Canon 3. Other professionals may file a complaint under Canon 4. It is important to note that this is not limited to cybersecurity professionals. Anyone who is certified or licensed as a professional and subscribes to a Code of Ethics as part of that licensure or certification is eligible to file a Canon 4 complaint. Complaints under the Code of Ethics must be in writing and in the form of a sworn affidavit. When ISC squared receives a properly submitted complaint, they will undertake a formal investigation. For more information on the complaint and investigation process, see isc2.org/ethics. Violations of the Code of Ethics may be punished by sanctions up to and including the revocation of an individual's certification. Ethics and the Internet. A variety of ethical frameworks also exist to help guide digital activities. These codes are not binding on any particular organization, but are useful references for ethical decision-making. RFC 1087. In January 1989, the Internet Architecture Board, IAB, recognized that the Internet was rapidly expanding beyond the initial trusted community that created it. Understanding that misuse could occur as the Internet grew, IAB issued a statement of policy concerning the proper use of the Internet. The contents of this statement are valid even today. It is important that you know the basic contents of the document titled Ethics and the Internet, Request for Comments, RFC 1087, because most codes of ethics can trace their roots back to this document. The statement is a brief list of practices considered unethical. Whereas a code of ethics states what you should do, this document outlines what you should not do. RFC 1087 states that any activity with the following purposes is unacceptable and unethical. Seeks to gain unauthorized access to the resources of the Internet. Disrupts the intended use of the Internet. Wastes resources, people, capacity, computer, through such actions. Destroys the integrity of computer-based information. Compromises the privacy of users. 10 Commandments of Computer Ethics. The Computer Ethics Institute created its own Code of Ethics. cpsr.org/issues/ethics/CEI. The 10 Commandments of Computer Ethics are as follows. 1. Thou shalt not use a computer to harm other people. 2. Thou shalt not interfere with other people's computer work. 3. Thou shalt not snoop around in other people's computer files. 4. Thou shalt not use a computer to steal. 5. Thou shalt not use a computer to bear false witness. 6. Thou shalt not copy proprietary software for which you have not paid. 7. Thou shalt not use other people's computer resources without authorization or proper compensation. 8. Thou shalt not appropriate other people's intellectual output. 9. Thou shalt think about the social consequences of the program you are writing or the system you are designing. 10. Thou shalt always use a computer in ways that ensure consideration and respect for your fellow humans. Code of Fair Information Practices. Another formative document that guides many ethical decision-making efforts is the Code of Fair Information Practices, developed by a governmental advisory committee in 1973. This code outlines 5 principles for handling personal information in an ethical and responsible manner. 1. There must be no personal data record-keeping systems whose very existence is secret. 2. There must be a way for a person to find out what information about the person is in a record and how it is used. 3. There must be a way for a person to prevent information about the person that was obtained for one purpose from being used or made available for other purposes without the person's consent. 4. There must be a way for a person to correct or amend a record of identifiable information about the person. 5. Any organization creating, maintaining, using, or disseminating records of identifiable personal data must assure the reliability of the data for their intended use, and must take precautions to prevent misuses of the data. Summary. Information security professionals must be familiar with the investigation process. This involves gathering and analyzing the evidence required to conduct an investigation. Security professionals should be familiar with the major categories of evidence, including real evidence, documentary evidence, and testimonial evidence. Electronic evidence is often gathered through the analysis of hardware, software, storage media, and networks. It is essential to gather evidence using appropriate procedures that do not alter the original evidence and preserve the chain of custody. Computer crimes are grouped into several major categories. And the crimes in each category share common motivations and desired results. Understanding what an attacker is after can help in properly securing a system. For example, military and intelligence attacks are launched to acquire secret information that could not be obtained legally. Business attacks are similar, except that they target civilian systems. Other types of attacks include financial attacks and terrorist attacks, which in the context of computer crimes are attacks designed to disrupt normal life. There are also grudge attacks, the purpose of which is to cause damage by destroying data or using information to embarrass an organization or person, and thrill attacks, launched by inexperienced crackers to compromise or disable a system. Although generally not sophisticated, thrill attacks can be annoying and costly. Finally, hacktivists take their potentially sophisticated skills and apply them to issues where they have a political interest. The set of rules that govern your personal behavior is a code of ethics. There are several codes of ethics, from general to specific in nature, that security professionals can use to guide them. The ISC Squared makes the acceptance of its code of ethics a requirement for certification. Exam Essentials. Know the definition of computer crime. Computer crime is a crime or violation of a law or regulation that is directed against or directly involves a computer. Be able to list and explain the 6 categories of computer crimes. Computer crimes are grouped into 6 categories: military and intelligence attack, business attack, financial attack, terrorist attack, grudge attack, and thrill attack. Be able to explain the motive of each type of attack. Know the importance of collecting evidence. As soon as you discover an incident, you must begin to collect evidence and as much information about the incident as possible. The evidence can be used in a subsequent legal action or in finding the identity of the attacker. Evidence can also assist you in determining the extent of damage. Understand the e-discovery process. Organizations that believe they will be the target of a lawsuit have a duty to preserve digital evidence in a process known as electronic discovery, or e-discovery. The e-discovery process includes information governance, identification, preservation, collection, processing, review, analysis, production, and presentation activities. Know how to investigate intrusions and how to gather sufficient artifacts from the equipment, software, and data. You must have possession of equipment, software, or data to analyze it and use it as evidence. You must acquire the evidence without modifying it or allowing anyone else to modify it. Know the basic alternatives for confiscating evidence and when each one is appropriate. First, the person who owns the evidence could voluntarily surrender it. Second, a subpoena could be used to compel the subject to surrender the evidence. Third, a law enforcement officer performing a legally permissible duty may seize visible evidence that the officer has probable cause to believe is associated with criminal activity. Fourth, a search warrant is most useful when you need to confiscate evidence without giving the subject an opportunity to alter it. Fifth, a law enforcement officer may collect evidence when exigent circumstances exist. Know the importance of retaining investigatory data. Because you will discover some incidents after they have occurred, you will lose valuable evidence unless you ensure that critical log files are retained for a reasonable period of time. You can retain log files and system status information either in place or in archives. Know the basic requirements for evidence to be admissible in a court of law. To be admissible, evidence must be relevant to a fact at issue in the case. The fact must be material to the case, and the evidence must be competent or legally collected. Explain the various types of evidence that may be used in a criminal or civil trial. Real evidence consists of actual objects that can be brought into the courtroom. Documentary evidence consists of written documents that provide insight into the facts. Testimonial evidence consists of verbal or written statements made by witnesses. Understand the importance of ethics to security personnel. Security practitioners are granted a very high level of authority and responsibility to execute their job functions. The potential for abuse exists, and without a strict code of personal behavior, security practitioners could be regarded as having unchecked power. Adherence to a code of ethics helps ensure that such power is not abused. Security professionals must subscribe to both their own organization's code of ethics as well as the ISC² Code of Ethics. Know the ISC² Code of Ethics and RFC 1087, Ethics and the Internet. All CISSP candidates should be familiar with the entire ISC² Code of Ethics because they have to sign an agreement that they will adhere to it. In addition, be familiar with the basic statements of RFC 1087. Written Lab. 1. What are the major categories of computer crime? Answer. The major categories of computer crime are military/intelligence attacks, business attacks, financial attacks, terrorist attacks, grudge attacks, and thrill attacks. 2. What is the main motivation behind a thrill attack? Answer. Thrill attacks are motivated by individuals seeking to achieve the high associated with successfully breaking into a computer system. 3. What is the difference between an interview and an interrogation? Answer. Interviews are conducted with the intention of gathering information from individuals to assist with your investigation. Interrogations are conducted with the intent of gathering evidence from suspects to be used in a criminal prosecution. 4. What are the 3 basic requirements that evidence must meet in order to be admissible in court? Answer. To be admissible, evidence must be reliable, competent, and material to the case. Review questions. 1. Devin is revising the policies and procedures used by his organization to conduct investigations and would like to include a definition of computer crime. Which one of the following definitions would best meet his needs? A. Any attack specifically listed in your security policy. B. Any illegal attack that compromises a protected computer. C. Any violation of a law or regulation that involves a computer. D. Failure to practice due diligence in computer security. Answer. C. A crime is any violation of a law or regulation. The violation stipulation defines the action as a crime. It is a computer crime if the violation involves a computer, either as the target or as a tool. Computer crimes may not be defined in an organization's policy, since crimes are only defined in law. Illegal attacks are indeed crimes, but this is too narrow a definition. The failure to practice due diligence may be a liability, but in most cases is not a criminal action. 2. What is the main purpose of a military and intelligence attack? A. To attack the availability of military systems. B. To obtain secret and restricted information from military or law enforcement sources. C. To utilize military or intelligence agency systems to attack other non-military sites. D. To compromise military systems for use in attacks against other systems. Answer. B. A military and intelligence attack targets the classified data that resides on the system. To the attacker, the value of the information justifies the risk associated with such an attack. The information extracted from this type of attack is often used to plan subsequent attacks. 3. Which of the following is not a canon of the ISC Squared Code of Ethics? A. Protect your colleagues. B. Provide diligent and competent service to principals. C. Advance and protect the profession. D. Protect society. Answer A. The Code of Ethics does not require that you protect your colleagues. 4. Which of the following are examples of financially motivated attacks? Choose all that apply. A. Accessing services that you have not purchased. B. Disclosing confidential personal employee information. C. Transferring funds from an unapproved source into your account. D. Selling a botnet for use in a DDoS attack. Answer: A, C, and D. A financial attack focuses primarily on obtaining services and funds illegally. Accessing services that you have not purchased is an example of obtaining services illegally. Transferring funds from an unapproved source is obtaining funds illegally, as is leasing out a botnet for use in DDoS attacks. Disclosing confidential information is not necessarily financially motivated. 5. Which one of the following attacker actions is most indicative of a terrorist attack? A. Altering sensitive trade secret documents. B. Damaging the ability to communicate and respond to a physical attack. C. Stealing unclassified information. D. Transferring funds to other countries. Answer: B. A terrorist attack is launched to interfere with a way of life by creating an atmosphere of fear. A computer terrorist attack can reach this goal by reducing the ability to respond to a simultaneous physical attack. Although terrorists may engage in other actions, such as altering information, stealing data, or transferring funds, as part of their attacks, these items alone are not indicators of terrorist activity. 6. Which of the following would not be a primary goal of a grudge attack? A. Disclosing embarrassing personal information. B. Launching a virus on an organization's system. C. Sending inappropriate email with a spoofed origination address of the victim organization. D. Using automated tools to scan the organization's systems for vulnerable ports. Answer: D. Any action that can harm a person or organization, either directly or through embarrassment, would be a valid goal of a grudge attack. The purpose of such an attack is to get back at someone. 7. What are the primary reasons attackers engage in thrill attacks? Choose all that apply. A. Bragging rights. B. Money from the sale of stolen documents. C. Pride of conquering a secure system. D. Retaliation against a person or organization. Answer: A and C. Thrill attacks have no reward other than providing a boost to pride and ego. The thrill of launching the attack comes from the act of participating in the attack and not getting caught. 8. What is the most important rule to follow when collecting evidence? A. Do not turn off a computer until you photograph the screen. B. List all people present while collecting evidence. C. Avoid the modification of evidence during the collection process. D. Transfer all equipment to a secure storage location. Answer: C. Although the other options have some merit in individual cases, the most important rule is to never modify or taint evidence. If you modify evidence, it becomes inadmissible in court. 9. What would be a valid argument for not immediately removing power from a machine when an incident is discovered? A. All of the damage has been done. Turning the machine off would not stop additional damage. B. There is no other system that can replace this one if it is turned off. C. Too many users are logged in and using the system. D. Valuable evidence in memory will be lost. Answer: D. The most compelling reason for not removing power from a machine is that you will lose the contents of memory. Carefully consider the pros and cons of removing power. After all is considered, it may be the best choice. 10. What type of evidence refers to written documents that are brought into court to prove a fact? A. Best evidence. B. Parole evidence. C. Documentary evidence. D. Testimonial evidence. Answer C. Written documents brought into court to prove the facts of a case are referred to as documentary evidence. The best evidence rule states that when a document is used as evidence in a court proceeding, the original document must be introduced. The parole evidence rule states that when an agreement between parties is put into written form, the written document is assumed to contain all the terms of the agreement, and no verbal agreements may modify the written agreement. Testimonial evidence is evidence consisting of the testimony of a witness, either verbal testimony in court or written testimony in a recorded deposition. 11. Which one of the following investigation types has the highest standard of evidence? A. Administrative. B. Civil. C. Criminal. D. Regulatory. Answer C. Criminal investigations may result in the imprisonment of individuals, and therefore have the highest standard of evidence to protect the rights of the accused. 12. During an operational investigation, what type of analysis might an organization undertake to prevent similar incidents in the future? A. Forensic analysis. B. Root cause analysis. C. Network traffic analysis. D. Fagan analysis. Answer B. Root cause analysis seeks to identify the reason that an operational issue occurred. The root cause analysis often highlights issues that require remediation to prevent similar incidents in the future. Forensic analysis is used to obtain evidence from digital systems. Network traffic analysis is an example of a forensic analysis category. Fagan inspection is a software testing technique. 13. What step of the electronic discovery reference model ensures that information that may be subject to discovery is not altered? A. Preservation. B. Production. C. Processing. D. Presentation. Answer A. Preservation ensures that potentially discoverable information is protected against alteration or deletion. Production places the information into a format that may be shared with others and delivers it to other parties, such as opposing counsel. Processing screens the collected information to perform a rough cut of irrelevant information, reducing the amount of information requiring detailed screening. Presentation displays the information to witnesses, the court, and other parties. 14. Gary is a system administrator and is testifying in court about a cybercrime incident. He brings server logs to support his testimony. What type of evidence are the server logs? A. Real evidence. B. Documentary evidence. C. Parole evidence. D. Testimonial evidence. Answer B. Server logs are an example of documentary evidence. Gary may ask that they be introduced in court and will then be asked to offer testimonial evidence about how he collected and preserved the evidence. This testimonial evidence authenticates the documentary evidence. 15. You are a law enforcement officer, and you need to confiscate a PC from a suspected attacker who does not work for your organization. You are concerned that if you approach the individual, they may destroy evidence. What legal avenue is most appropriate? A. Consent agreement signed by employees. B. Search warrant. C. No legal avenue necessary. D. Voluntary consent. Answer B. In this case, you need a search warrant to confiscate equipment without giving the suspect time to destroy evidence. If the suspect worked for your organization and you had all employees sign consent agreements, you could simply confiscate the equipment. 16. Gavin is considering altering his organization's log retention policy to delete logs at the end of each day. What is the most important reason that he should avoid this approach? A. An incident may not be discovered for several days, and valuable evidence could be lost. B. Disk space is cheap, and log files are used frequently. C. Log files are protected and cannot be altered. D. Any information in a log file is useless after it is several hours old. Answer A. Log files contain a large volume of generally useless information. However, when you are trying to track down a problem or an incident, log files can be invaluable. Even if an incident is discovered as it is happening, it may have been preceded by other incidents. Log files provide valuable clues and should be protected and archived, often by forwarding log entries to a centralized log management system. 17. What phase of the electronic discovery reference model examines information to remove information subject to attorney-client privilege? A. Identification. B. Collection. C. Processing. D. Review. Answer D. Review examines the information resulting from the processing phase to determine what information is responsive to the request and remove any information protected by attorney-client privilege. Identification locates the information that may be responsive to a discovery request when the organization believes that litigation is likely. Collection gathers the relevant information centrally for use in the e-discovery process. Processing screens the collected information to perform a rough cut of irrelevant information, reducing the amount of information requiring detailed screening. 18. What are ethics? A. Mandatory actions required to fulfill job requirements. B. Laws of professional conduct. C. Regulations set forth by a professional organization. D. Rules of personal behavior. Answer D. Ethics are simply rules of personal behavior. Many professional organizations establish formal codes of ethics to govern their members, but ethics are personal rules individuals use to guide their lives. 19. According to the ISC Squared Code of Ethics, how are CISSPs expected to act? A. Honestly, diligently, responsibly, and legally. B. Honorably, honestly, justly, responsibly, and legally. C. Upholding the security policy and protecting the organization. D. Trustworthy, loyally, friendly, courteously. Answer B. The second canon of the ISC Squared Code of Ethics states how a CISSP should act, which is honorably, honestly, justly, responsibly, and legally. 20. Which of the following actions are considered unacceptable and unethical according to RFC 1087, Ethics and the Internet? A. Actions that compromise the privacy of classified information. B. Actions that compromise the privacy of users. C. Actions that disrupt organizational activities. D. Actions in which a computer is used in a manner inconsistent with a stated security policy. Answer B. RFC 1087 does not specifically address the statements in option A, C, or D. Although each type of activity listed is unacceptable, only actions that compromise the privacy of users are explicitly identified in RFC 1087. Chapter 20.